Yeah, please, my lord. My lord, I beg to mention item number 24. ma'am.
Oh,
Yes, ma'am.
it was a hearing matter. So what has happened?
My lord.
You pray for an adjournment here?
Yes, my lord. Matter may be my lord kindly taken on Tuesday, my lord.
Tuesday is not possible. Tuesday is already lots of matters has been fixed. Even in division bench also lots of matters. So maybe episode it took 15, 16 you can do it. 20. 20. 20 is Monday. Take it on 20. And why do you need the adjournment? Mr. Panging is present today.
Yeah, my lord, his legs in court one, my lord. So it could not be taken up today.
Due to personal difficulty of the NTS Council, Mr. P. Pang, he will have also pursuant to paid for adjournment. Let the matter be listed on 20.
Okay.
Logic, mattering on behalf of my senior Islam, reached out of so due to some domestic problem, my logic, would like to pray for the benefits of the four.
You are appealing for who? Appellate.
Yes.
Have you informed the other side
Yes,
also?
yes. We have
Because yesterday only that thing that happened that I have inquired whether the matter has been informed to the other side. The council was appealing before me, said that yes. And subsequently I come to know that no information was given. So that should not be.
you have taken the consent from the other side.
The consent of the other side, the Dalit council for the appellant for an adjournment. Yes, for whom? Who is the in this council? You have said
Islam.
S.
Islam.
Okay, number 19.
23.
20? Oh, 23. Achha, okay. 23. List of the police. Ten. Nine. Yes.
I'm for the petitioner. So my leading counsel is out of station.
Who is your leading counsel?
Vijay.
Same order for you.
So the matter may be kindly fixed for me Thursday.
No, not Thursday. 21, 11.
May I, my lord? My lord, I beg to mention item number 19, my lord. Learned Council for the petitioner, my lord. Mr. Modi is out of station. Therefore, my lord, matter may be fixed after 6 weeks.
Well, most of the advocates are out of station. Why?
Yes, my lord.
Holiday is still continuing or what?
Continue, my lord, interim order.
For you, holiday is still continuing.
Yes, my lord.
Vacation is still continuing. Okay. Yes, list after
6 weeks, my lord.
6 weeks.
Yes.
He will be out of station for 2-3 months.
Yes, actually, I have taken consent from respondent side, my lord.
No, why you need 6 weeks? Mr. Modi will be out of station for 2 months.
Yes, my lord. Actually, my lord, Mr. Tang for the respondent also out of station, my lord.
Oh, you're praying for them also.
Yes, my lord.
After 4 weeks. Just after 4 weeks. Not 6 weeks after 4 weeks.
Obliged, man.
Madam. Item number 18. The leading councillor Duyulaji has fallen sick, so I would like to pray for yes.
Duyulaji?
Yes, madam. After 2 weeks, madam.
Paying adjournment. stating that the Learned Counsel, Mr. Gilardi is in this post. Let the matter be listed after 2 weeks.
Yes, please. Alright. My lord, I'd like to mention item number 15 on behalf of Advocate T. Time.
He is also out of station.
Yeah, due to medical issues, the letter of absence also submitted from 7 to 17.
Letter of absence has already been submitted.
Yes, my lord.
7 to 17.
Yes, my lord. The matter will be released for 2 weeks.
You are Mr.
T. Dai, Torab Dai.
T time is the
No.
case comes in your name.
I'm Torab Dai, T. Dai.
You also T time.
T. Dai, D-A-I. Dai. T. Dai,
Equal to D. And D.
Torab Dai.
The Learned Counsel in appearing on behalf of the youngest counsel, Mr. T time. They submitted that he is out of station and their absence notice already been filed before the registry. They are allowed. Let the matter be accordingly listed. You want?
For 2 weeks.
Huh? 2 weeks.
2 weeks, my lord. Much obliged.
There, please, your lordship. Since your lordship, this is second round of litigation before this honorable court on the same subject matter. So therefore kindly come to the last order, previous order that was passed by this honorable court. That is at page 63, madam.
Please.
63. Same subject matter. And to my humble understanding, the learned court below has not properly understood what was the intent of this honorable court while disposing of this matter. May I read the judgment. This is of dated 21/8/2023. Page 63, heard Mr. So-and-so, learned counsel for the petitioner, also heard Mr. So-and-so, additional public prosecutor for the respondent number 1. This revision petition under so-and-so of the CRPC has been filed challenging the order dated 30/3/2023, passed by the learned CGM Daporizio in Daporizio CR case number 4 of 2022, whereby the complaint filed by the respondent number 2 against the petitioner under section 190/200 CRPC for taking cognizance of offense under section 193 IPC against the petitioner and thereby fixed the complaint case on 22/5/2023 for examination of the complainant and witnesses under section 200 of the CRPC. Also put to challenge is the order dated 22/5/2023 passed by the learned CGM Daporizio in Daporizio CR case number 4 2022, whereby summons were issued to the petitioners for appearance on 23/6/2023. And the order dated 5/8/2023 passed by the learned Chief Judicial Magistrate Daporizio in Daporizio case number 4 of 2022 on a misapplication number 8 of 2022 filed by the petitioner number 1 for stopping the proceeding of the complaint case number so-and-so, contending that the same is barred by section 195(1)(b) Roman small I of CRPC 1973, which contention was rejected, and 12/9/2023 has been fixed for appearance of both the petitioners. The order dated 30/3/2023 by which the complaint case number Daporizio complaint case number 4 of 2022 filed by the respondent number against the petitioners for the offense under section 193 IPC against the petitioners have been taken cognizance of by the learned Chief Judicial Magistrate Daporizio is reproduced herein below, my lord. Order, my lord, so-and-so, so-and-so, so-and-so. Kindly come to page 67, my lord. Paragraph 8, the relevant portion. This is the observation of this honorable court. Section 195(1)(b) Roman small 1 of CRPC provides that no court shall take cognizance of any offense punishable inter alia under section 193 of the IPC, except on the complaint in writing of that court or by such officer of the court as that court may authorize in writing in this behalf or of some other court to which that court is subordinate. 9. In the instant case, there appears to be no complaint in writing of the court or by such officer of the court as that court may authorize in writing in this behalf alleging commission of an offense under section 193 of IPC, namely giving false evidence in any stage of the judicial proceeding, etc. Thus, in the absence of complaint in writing of the court or by such officer of the court as that court may authorize in writing in this behalf, herein a false evidence at any stage of judicial proceeding is alleged to have been given, the learned Chief Judicial Magistrate Daporjo could not have taken cognizance of an offense under section 193 IPC on a complaint lodged by the respondent number 2, as has been done by the impugned order dated 30/3/2020. This was the, my lord, observation of this honorable court. 11. Where such complaint is lodged for an offense under section 193 IPC, the proper course of the court concern is to follow the provisions of section 195 and 340 of the CRPC and proceed thereafter. 12. In view of the matter and with the consent of the learned counsel for the petitioner as well as learned ADPP, this revision petition is disposed of at the motion stage itself by setting aside the orders dated 30/3/2023, 22/5/2023, and 5/8/2023, passed by the learned Chief Judicial Magistrate Daporjo in Daporjo CR number 4 of 2020, with a direction to the learned Chief Judicial Magistrate Daporjo to act in accordance with the provisions of section 195 and 340 of the CRPC on the complaint filed by the respondent number 2 against the petitioner. This was the, my lord, direction. Now, lordship may kindly see the impugned order again. That is at page 69. This is, my lord, 12 September 2023. I have impugned this order. Complainant and his counsel are absent. Accused has appeared with his counsel, Mr. So-and-so. Case speaks for necessary order. Honorable Guwahati High Court, Itanagar Permanent Bench, by order dated so-and-so in criminal revision petition number so, has directed this court to act in accordance with the provisions of section 195 and 340 of the CRPC on the complaint filed by the complainant against the accused person. In view of the above, the complaint filed by the complainant under section 190 read with section 200 CRPC is treated as application under section 340 CRPC. To that extent, my lord, lordship, it is correct. This court is of the opinion that it is expedient in the interest of justice that an inquiry should be made into the allegation made by the complainant. Accordingly, issue summon to the complainant for recording his statement, list on 5th October 2023 for recording a statement of the complainant. Now, of course, the learned court below is authorized to do inquiry as per section 340. Now, kindly come to the next order. That is at page 72, lordship. This is of PIP 10/2023. Last page. Page 72. Complainant and his counsel are present. Case is fixed today for recording of statement of the complainant. The statement of the complainant is recorded in a separate sheet. Having heard the complainant and perusing the documents produced by him, I find prima facie case under section 193 IPC against accused persons, namely Sri Takar Rai and Srimati Yarishum, that they are the petitioners. Accordingly, my lord, cognizance of the offense under section 193 IPC is taken against both the accused person. So despite of repeated direction that you have to comply with the provisions of law, that is 195 and 340. So this is in other language, this is willful contempt or not appropriately appreciating with what intent this honorable court has disposed of that matter, the previous litigation. So finding no other option, lordship, we are here again to get it set aside and quest. And last paragraph, send the case record to learned JMFC Daporjo for trial and disposal of the complaint. The learned JMFC Daporjo shall proceed as per section 340 3 of the CRPC. In the first hand, Your Lordship, the learned trial, the learned CGM Daporizio ought not to have taken cognizance, which is not permissible as per the law. Therefore, we have come up again with this revision petition. So in this context, let the notice go, and meantime this impugned order may be suspended so that unnecessarily these petitioners do not appear before the learned MFC Daporizio.
May it please, Your Lordship. Your Lordship, the learned court below has erred in understanding Your Lordship provision of section 340, Your Lordship. Because Your Lordship, the evidence, whatever is given before the court below has the CGM itself, Your Lordship. And as per section 340, Your Lordship, the CGM can hold preliminary inquiry, and that is also not mandatory also as per the settled law held by the Honorable Supreme Court in Ketina of judgment. So, but if she wish to conduct a preliminary inquiry, Your Lordship, she can exercise his power to that extent only. That will not amounting to finding out the guilt of the accused. It's just a preliminary inquiry whether prima facie case is made out or not. If he found that prima facie case is made out, then same has to be forwarded to the learned judicial magistrate first class for taking cognizance under section 200 of the CRPC, Your Lordship. So here he has exceeded his jurisdiction, Your Lordship. We misunderstood the direction given by this honorable court, Your Lordship. So for that, Your Lordship.
Is there the number 2 is the
Private
private
respondent, complainant.
Now, whether if Your Lordship may kindly see this judgment, Your Lordship, for Your Lordship convenience, Your Lordship, because at this stage also this can be disposed of because procedure error is there, Your Lordship. So if it is clear, Your Lordship, without taking much time, without keeping this matter pending, Your Lordship may quash the matter and with liberty to the concerned court to follow as per the settled procedure laid down by the Honorable Supreme Court, Your Lordship. I will rely the judgment held by the Honorable Supreme Court and Prithis, Your Lordship. It will make everything clear, Your Lordship. The procedure is given here.
private facie shows that he again is the same.
Yes,
Same
Your
thing
Lordship.
will be repeated
Your
again.
Lordship,
Therefore,
if the
Lordship, my prayer that notice may be issued,
If Your Lordship,
matter may be suspended as because entire proceeding also I have challenged in this revision petition. Because what I found, these petitioners, Lordship, allegation in that complaint case is that they have falsely deposed before the learned trial court below during the trial of another case, that despite they being married to each other, they have deposed before the court that they are not married to each other. That is the allegation. And to substantiate that,
Your challenge is regarding the entire proceeding will come later on, but the question is that there is a wrong procedure between
that is apparent on the face of that.
Your Lordship, so indicating if Your Lordship inclined to dispose of this matter, then Your Lordship, if Your Lordship find it relevant, then this procedure may be, Your Lordship, reflected in the order so that the learned court below can accordingly follow the procedure. Your Lordship may kindly come to para 8. This is the judgment reported in 2002-1 SCC 253. Para 8, Your Lordship. I will start from para 8, 9 and 15. I will rely, Your Lordship. May I read, Your Lordship? Reading of subsection make it clear that the hub of this provision is formation of an opinion by the court below, which proceeding were to be held. That is expedient in the interest of justice that an inquiry should be made into an offense which appears to have been committed. In order to form such opinion, the court is empowered to hold a preliminary inquiry. It is not peremptory that such preliminary inquiry should be held. Even without such preliminary inquiry, the court can form such an opinion when it appears to the court that an offense has been committed in relation to a proceeding in that court. It is important to notice that even when the court forms such an opinion, it is not mandatory that the court should make a complaint. This subsection has conferred a power on the court to do so. It does not mean that the court should, as a matter of course, make a complaint. But once the court decided to do so, then the court should make a finding to effect that on the fact situation, it is expedient in the interest of justice that the offense should further be proved into. If the court finds it necessary to conduct a preliminary inquiry to reach such finding, it is always open to the court to do so, though absence of any such preliminary inquiry would not vitiate a finding reached by court regarding its opinion. It should again be remembered that preliminary inquiry contemplated in subsection is not for finding whether any person is guilty or not. Far from that, the purpose of preliminary inquiry, even if the court opt to conduct it, is only to decide whether it is expedient in interest of justice to inquiry into the offence which appear to have been committed. Para 9. Inquiry is defined in section 2G of the code as every inquiry other than a trial conducted under this code by a magistrate or court. It refers to the pre-trial inquiry, and in the present context, it means the inquiry to be conducted by the magistrate. Once the court which form an opinion, whether it is after conducting the preliminary inquiry or not, that it is expedient in the interest of justice that an inquiry should be made into any offence, the said court has to make a complaint in writing to the magistrate of first class concern. Here it is clearly mentioned, the procedure. As the offence involved are all falling within the purview of warrant case, as defined in section 210 of the code, the magistrate concerned has to follow the procedure prescribed in chapter 19 of the code. In this context, we may point out the 343 of the code specify that magistrate to whom the complaint is made under section 340 shall proceed to deal with the case as if were instituted on a police report. This being the position, the magistrate on receiving the complaint shall proceed under section 238 to 243 of the code. Section 238 of the code says the magistrate shall at the outset satisfy himself the copy of all the relevant documents have to be supplied to the accused. Section 239 enjoined on the magistrate to consider the complaint and the documents sent with him. He may also make such examination of the accused as think necessary. Then the magistrate has to hear both the prosecution and the accused to consider whether the allegation the accused are groundless. If he find allegation to be groundless, he has to be discharged. This is after filing the complaint before the JMFC. Your Lordship. Yes. So this procedure has been clearly been laid down, Your Lordship. He can hold preliminary inquiry, and it is not peremptory also, Your Lordship. Then complaint has to be filed before furnished before the CG learned judicial magistrate first class as per the provision of section 340, which he has not complied with.
So, yeah, the earlier most probably there are two orders, na? One order is at page 72, where he again after taking cognizance he again given to the London Council, London GMFC.
Lords.
He took the cognizance.
Yeah.
That's the main issue. So
Yes, deposition has been taken, Your Lordship.
yes.
So that ought not to have done because he has taken cognizance by himself, Your Lordship. He cannot do it. He's
Cannot do it.
without jurisdiction.
Exercise the power given under section 200 CRPC. On
Yes.
what examination that ought not to have been done. So if my learned brother, learned PP is of the opinion that matter can be disposed of, that is also okay. But then again, if the direction of this whole code is again misunderstood, again, if learned trial court below take cognizance, tomorrow there will be difficulties, well.
But
Repeatedly.
the question is that the evidence which has been given false evidence or whatever, rightly or wrongly,
Lordship.
to cognizance, that cannot be disposed of. Then definitely direction can be given
Lordship.
to follow the proper procedure. But the entire matter cannot be disposed of that this is a false evidence was not.
Yes, exactly. Not on merit,
By
Your
the
Lordship.
merit of the case.
Yes, yes, Your Lordship.
And that is there. So either this petition can be instantly disposed of.
Lordship.
I don't think that notice on the response number 2 will be required because privacy.
Yes, yes.
Apparently, Lordship.
Yes. As the order, so this is disposed of.
Lordship.
There definitely there will be direction to the court below.
Lordship.
Oblige, Your Lordship.
Meantime, Lordship, pending, this will be, judgment will be delivered, Lordship.
No, by today and
Today. Lordship.
a short judgment.
Highly.
Oblige, Your Lordship.
Will come.
May I, Your Lordship?
Item number 2.
Yes, Lordship. Lordship, I'm appearing on behalf of the petitioner. And this petition is filed under section 482 CRPC for quashing an FIR dated 04/08/2023, case number bearing 171 by 2023, Lordship. Lordship, in the FIR, in the aforesaid FIR, there is nowhere mentioned about the petitioner. The name of the petitioner is not mentioned in the FIR. However, despite this fact, notice under section 41A(1) of the CRPC has been issued to the petitioner, Lordship. So, Lordship, we would pray before this honorable court to please issue a notice to the respondent. Because in the FIR, there is no mention of the petition.
41A, whether he appeared before the IO.
No, Lordship.
We have directly come to before this court for question.
Yes, Lordship.
So this name is not there.
Otherwise, in this case is not maintainable. Mr. A files in a complaint against Mr. B. and C comes before my lord for quashing of FIR.
Her only intention is that she received a 41A.
A notice.
So
Yes,
if you
Lordship.
received this
And in that-
41 no,
Yes,
no, see,
Lordship.
If you suppose received the 41A, or if you have any apprehension of being arrested in this case, wherever the other option is there for you to file a anticipatory or whatever. If you've already received the 41, but how can-
Quashing is not
Quashing
possible.
is quite absolutely maintainable.
Lordship,
And
because
there you have submitted that there is no mention against you in the FIR.
Yes,
Only
Lordship.
on the basis of the 41A.
Not possible, my lord.
Because Lordship, in FIR, like the allegation is made against and the complainant who has made the complaint, he is the third party, Lordship. Like in the FIR, it has mentioned about an agreement, money agreement, Lordship. And that money agreement is between two different parties and not the person who has filed the FIR, Lordship. And
Madam-
this lordship money agreement, and when it, as far as the money agreement or any kind of agreement is concerned, then it comes under the civil dispute, Lordship. It will be not
All
a
these will
criminal.
come, but the point he raised by the
Yes.
RPP, that you are not the FIR named accused. Till now, there is no, you are not in the picture also. Except there you have noticed, received the notice. On that basis.
No, my lord, cannot be done, man. Since, in fact, the petition has no locus standi in filing the present petition also, my lord.
Mm.
Since Mr. A files in a FIR before the police station against Mr. B.
Mm.
Now C comes before my lord for quashing of the petition. That cannot be done. And this matter is under investigation. My lord has rightly observed, in case if they have a apprehension, my lord, since they have received a notice under 41A, they can always
Yes.
file an anticipatory bail application, my lord.
Suppose you have received the 41A for, maybe for inquiry and all for, you may not be entangled in the case also. Or rather, if you have any application, and he said that,
Lordship, we would also request for protection from this court because we have been receiving threat
protection
and
you
calls
can seek protection from,
till we file this till we file for anticipatory bail, if we
Mm,
could
that
be given
now
protection,
you have
Lordship.
only receive the 41A only. You just, this option is also again for you to open for you to, you can appear before the IO also. For, just for an inquiry also, he may issue a notice on 41A. I don't think that is.
Your Lordship, we have received the threatening messages also, Your Lordship. And since then,
What messages?
threatening messages we have
From
received
whom?
from this complainant, Your Lordship.
Or that is.
Then they can file a separate FIR, my lord.
If any threatening message you have received, so what is your name? No, not your advocate's name, the petitioner is Praveen Kumar Jain.
Praveen Kumar Jain, yes, Lordship.
So as per FIR, let's see the FIR
Page number 19.
in 19.
FIR against Kalidas Jain.
Hmm.
And filed by Mahesh Kumar
Kalidas
Jain.
Jain.
Yes, Lordship.
Kalidas Jain filed by one Manish Kumar Jain.
Mahesh Kumar Jain.
So we were in the picture here. Okay,
Look, that makes, this matter
Lordship.
can be withdrawn and they can always file in separate application if they are apprehending arrest or anything, my lord.
Lordship,
If
we would
you are
like-
Washing
attending
is
a
not
restaurant, if
possible.
there is any threatening on the part of from the complainant, what options are there? You can understand what I'm saying or what he is
Yes,
saying,
yes,
that's why,
Lordship.
because now, as he well explained that A files an FIR against B, and you are only C. You don't have any relation with A and B. So how can you pray for a quashing of the FIR? That is the thing. You are not at present, you are not in this picture or scenario. Subsequently, you may come or even if. Okay, So it will not be cause any prejudice to you even if we dispense the petition because it is not at all maintainable. And rather the option is very good. Options are with you. You can file for a seek for a anticipatory bail. Or if you any such kind of threatening is there, you can file on FIR also. That is the best option open for you. Okay. Washing is not at all possible. I mean, it's not maintainable. You are Miss
E Mosang,
E.
Mosang, M-O-S-S-A.
Your name is not reflected here, no? One, two no jano mero. Two. J.
She is the leading counsel. Our name is mentioned in Wakalat Nama.
Okay, anyway, what is your name?
T Mosang.
E. Mosa, her MS E. Mosa, United Council, appearing on behalf of the petition and also her Mr.
Lordship, may I please?
Ah.
Lordship, we would like to mention that the Kalidas Jain, who is the father of the petitioner, he has been abducted, Lordship, till date. And various complaints have been filed by Praveen Kumar Jain on dated 14/08/2023 and 16/08 before PS Itanagar as well as in Rajasthan, Lordship. But after filing such complaints, many threatening calls have been received from the respondent side, Lordship. And I doubt that the police personnel of PS Itanagar, they are involved in this conspiracy, Lordship. So till filing of the anticipatory bail, if we are given protection from this honorable court, then it would be.
Protect you. Now, question is there is nothing against you in the FIR. Plain reading of FIR, it is filed against one Kalidas. He may be your father, I don't know,
Yes,
whatever. Now, against Kalidas only. So against you, there is nothing in the FIR. So protection also will, the question of protection, how will come? Immediately tomorrow or by the after Monday, you can file an anticipatory if the position is that way.
Yes, ma'am. Altogether, that is a different subject matter, and for that, there's a different FIR, ma'am.
In abduction is there or whatever. You can very well file an FIR also. Or for your self-protection, you can file an anticipatory. If there is any apprehension in that way. Pardon, Mr. So-and-so, the lunch was sent Mr. So-and-so. This is an application in section 482 CRPC. Pay for washing on. Paying for washing of FIR bearing number 171/2023 dated 4/8/2023 under section 420 IPC before the Itanagar police station. Itanagar police station. What is the number of the case you have not mentioned?
Yes.
It is mentioned in FIR in
Lordship,
1718
171.
of 2023.
1010.
Registered as 171 of 2000, Itanagar PS 171 2023.
Lordship, kindly reflect the anticipatory bail in the order copy, Lordship. To
She is
reflect the
submitting that-
anticipatory bail in the order copy, Lordship.
An anticipatory bail application can file a separate, there's no issues in that. It cannot be reflected in the order.
See,
About
yeah,
to also take
just I'm explaining, I think you're not following me. But the question is, you have the apprehension, isn't it? On being arrested in this case, on as well as on the already have received the 41 ACRPC notice also. I am suggesting you immediately you can file anticipatory bail next tomorrow itself or by today itself. So nothing more. That is the procedure. That's what I'm saying. For your protection or if you think that. But in that case also, it will be difficult on our part to give you, I don't think, because seeking will be necessary. Probably. Otherwise, we don't have anything against you
Yes.
for any protection. Anyway,
Actually, earlier one petition was filed where we had withdrawn with liberty because in that petition we did not mention the complainant's name as party, Lordship. So with liberty we had withdrawn it, and this is a new petition, Lordship. And the earlier petition was with the title Praveen Kumar Jain versus State of Arunachal Pradesh.
Look, that earlier petition was withdrawn since they have not completed the complainant as a party.
Yes.
So that liberty was given. Now this is a fresh application.
So on that, almost probably liberty was given and we were before this court with a fresh petition. That's it. So and so, this application, so and so will the learned counsel for the petitioner submitted that the name of the present petition is not reflected in the FIR, but they have already received a notice under section 41 CFPC from the IO, and hence there's an apprehension that he may be entitled in this case, and accordingly, the present petition is filed for quashing of the FIR. Registered under Itanagar Police Station case number 0. But from she further submitted that the petitioner also received some threatening phone calls from the Itanagar Police Station, and thus she had the apprehension of being arrested in connection with this case. In this context, Mr. Seri, the learned PP, has submitted that the petition is not maintainable at this stage because as the name of the present petition is nowhere reflected in the FIR, and he has no local standi to file a petition for quashing of the FIR, wherein he is not, where his name has not been reflected or he in the reflected construct. Accordingly, it is submitted that the petition is able to be dismissed as same is not maintainable. After hearing this submission made by the learned counsel for both sides, I have produced the record and the FIR. And it is from the FIR, it reveals that the FIR that the same is lodged against Kalidas Jain by the informant one Manish Kumar Jain with some allegation of misappropriation of money, etc. Misappropriation for the allegation of cheating, with the allegation of criminal conspiracy and cheating. However, the name of the present petitioner appellant is not mentioned in the FIR, though there may be some involvement of the present petition, but at present there is nothing in the FIR to accept the petition for quashing of the FIR under section 482, quashing of the FIR which is registered under section so and so against so and so. In considering the entire circumstances of this case, I find that the present petition is not at all maintainable in the present form, and accordingly the same stand dismissed. However, the petitioner is at liberty to approach the other forum for other forum if for his protection. The above observations is that. So I have already mentioned that you have a liberty to approach.
Much obliged, Lordship.
This matter is also similar to item number 1, that's not happened. This was the impugn order, Lordship.
Similar to item number 1.
Lordship. Impugn order is at page 16.
16.
Yes, sir. Lordship. And the relevant portion is at page 18, Lordship. Kindly into page 18.
Your Lordship, the outset, I will advise the court. It was they filed the bail earlier, Your Lordship, the anticipatory bail in the same case.
They have also moved one anticipatory bail also.
Day before yesterday, it was listed, Your Lordship, was called for CD, Your Lordship. Under 195A, the session court is directed for registration of FIR. So now they are challenging that order by way of under 482 application. challenging the
Can
procedure.
it be listed, the other matter is listed on?
Your lordship, in fact, if this matter is taken up and your lordship will dispose of the matter, then automatically this anticipatory bail will be in fluctuation, your lordship.
Anyway, when the anticipatory bill is fixed on?
Fix your lordship,
On 14.
14.
It's the matter on 14.
Worship, here the issue is altogether different issue. I have raised altogether different issue. Worship, kindly page page 18.
No, no, the
Para
question
two.
is that they most probably have prayed for an anticipatory also in this regard. So,
They have
I
tried,
think, it can be listed on 14.
your lordship, here also the issue, your lordship, here
Lordship.
also the issue of law is there, your lordship, procedure regarding, because your lordship, the anticipatory bail, no doubt, and for anticipatory bail, the court will decide the matter on the basis of materials collected by the investigation. But here in this case, your lordship, whether the procedure under 195A has been complied by the learned court below or not, that has been assailed. They are challenging on the law, your lordship. So, your lordship, if they,
Absolutely on the basis of law, and I am relying on the judgment also lordship passed by this honorable court.
The other matter, the question was a bit different because one kind of, first kind of litigation was already there.
Yes.
Whatever was the direction.
yes, your
But
lordship,
here I think that we can address issue notice otherwise. Here,
yes, your lordship. Here, your lordship, the issue is regarding the threatening to the witness. So now, your lordship, there, the procedure has been prescribed in 195A. And as per 195A, the complaint has to be lodged by the concerned witness or any other person. But your lordship, or any other person doesn't include court. So if suppose a person file a complaint to the court, then court has to file a complaint to the JMFC, your lordship, according to section 340. Here also, your lordship, the concerned magistrate has exercised the power under section 156(3), which is not permissible, and he has directed the learned court, investigation officer or investigation authority to register the FIR. That has, your lordship, that proposition has already been settled by our own court, your
no,
lordship.
I think I'll give the matter on 14th only.
Okay,
Or
it's up,
I can issue the notice, whatever.
Lordship.
it's up to your lordship, yes.
I pray that lordship, I issue notice. Till then, your lordship, the impute order may be suspended. Because there is a completely violation of law. Procedure of law has not been followed.
Hard Mr. Akeshi, the Learned Counsel for the petition, okay, hard Mr. TA taken and the registration, being on behalf of state respondent. This is an application section 482 CRPC, and so against the impute order, it is 16/10/2023, passed by Learned Special Judge Pokso. West Coming district, West Coming. The district of West Coming,
East coming and Tawang, covering 3 districts, lordship.
Coming and Tawang and Tondela, Yukiriwa, DSP, both Kira coming. And the subsequent FIR dated 20/10/2022 will be registered as Tawang Police Station case number 16/2023 under section 120B/195A IPC. Issue notice to the respondent number 2. No formal notice is required to be issued to the respondent number state respondent as the learned additional PP has already appeared before the court. However, the extra copies will be served to the SOS, they will be posted to the SOS. Further considering the prayer of the learned counsel for the petition, now where you have annexed the order
Lordship.
at page 16.
Lordship. Page 16. Order dated 16/10/2023.
Annexure A.
Now, what is the fix for prosecution witness?
Lordship, that is on
On-
13th.
Huh?
Yes, lordship, fixed for prosecution witness. Only one witness left, that is doctor.
Your lordship,
Otherwise, just a.
Otherwise, almost
this is different, arising out of this proceeding only, your lordship, this allegation has been cop up, your lordship. This is the POXO case, this is going on.
this is
No,
on-
POXO case is going on.
Yes,
I'm
Your
not on POXO, I
Yes.
want this 120 or 195A.
On
No,
POXO
your
only
lordship,
that order was passed, your lordship. On POXO proceeding only that order was passed, your lordship.
this order was passed in POXO proceeding for
It-
registration of FIR.
Now, FIR has already been registered.
Registered, so that FIR also I have annexed.
FIR.
That's why I said subsequent.
So that on the basis of that FIR, the matter is still under investigation.
Yes.
Yes, your lordship. During the pendency
Then-
POCSO matter only, the learned court below has passed the order for registration of FIR. This is the issue here. your lordship.
You want to- What to stay? What? No, he was, no, he
He is praying for your lordship stay of the investigation, your lordship.
investigation.
Yes, your lordship.
Your Lordship, but this impugn order. 16/10/23.
15/3/23 is a part of the order, the otherwise the other order is also there regarding the POCSO also.
Yes, exactly, your lordship.
Cases before. Now, we cannot stay the entire order because the cases fixed for the.
No,
witnesses.
particularly in respect of the petitioner only. I'm not talking.
Your lordship, in paragraph, your lordship may find in page number 18. This is the paragraph pertains to this FIR, your lordship.
Yes.
Paragraph 18, only they are impugned by this paragraph only, your lordship. Page number 18, your lordship. From the above material available in record, it is found that there is a criminal conspiracy amongst Sring Norbu, Srimati so and so, and Karma so and so for threatening and deterring victim witness Nangjor Wanghum for deposing evidence against so and so. Such threatening and inducement of victim is evident from her deposition SPW1. Hence, it is observed that the said so and so are involved in commission of criminal conspiracy and threatening of the victim for adducing false evidence before this court. As such, offense under section so and so are attracted against the accused person. Hence, it is ordered the OCPS Tawang shall register a PS under PS case under appropriate section of law and conduct investigation and submission. Only this portion, not all the orders, your lordship.
They are considering this as relative, the execution of order,
Pertains-
in the respective portion of the order, it is 16/10/2023, the state till length date of listing, which is as follows, will you put, just give me, I'm going to
Inverted comma.
the entire under inverted comma you do this from so and so. Flag attack orientation. One flag is there from so and so to so and so.
This page 18, second paragraph only.
Yes, I'm marking.
Hmm.
It's the matter accordingly. Then it will be not on 14 because notice will be issued, so. 10-15 days will be required, I think.
Yes, if your lordship is staying the matter, then it may be fixed on any other day because LCR will come in the other.
Up to 3 weeks.
Okay.
I'll say because. Scan copy will say because. Scan copy also will not be because FIR in the investigation is also there, na?
Yes, your lordship. Your lordship,
That
your lordship, the
means-
LCR is perhaps not required because your lordship, only this is the portion. CD
The issue raised by me is
only on procedure part, your lordship. They are not required
laid
also.
down by the honorable court also.
Okay.
Deeply obliged.
List up to 3 weeks. eh?
May I please, your lordship? Lordship, application file under section 4822 of CRPC, lordship. Regarding that, lordship, one FIR has lost, lordship. May I read the FIR, lordship?
2710 is non-compoundable.
Yes. Only one section is not compoundable, lordship. And the
This is the joint petition or joint petition?
yes, joint petition, lordship.
So you have compromised the matter now.
Yes, yes, lordship.
So is there any report that you have bear the
And
so it is the basically damage of some vehicle and all, I think.
just nominal damages, lordship, because
So whatever, have you bear the expenses of the repairing and all?
yes, all are done, lordship. Lordship, that my humbly praise that lordship kindly may be quite satisfied.
Yes.
Lordship, they have the camp on settlement, lordship. Yeah, the settlement also, lordship, they have agreed to repair their own respective cars, lordship. So this is a small collision, lordship, of the car, then it can be disposed, lordship. But if today, lordship, possible, then only notice may be, then that's that, lordship. Otherwise, if Lordship is like to dispose today, Lordship, it can be Lordship at my issue. Lordship.
So the case is pending at the stage where it is
It's
already been charge sheeted or not been charge?
It's yet not charge sheeted is filed, but the yet not trial is going on, Lordship.
Charge sheet has already been.
Yes, it's a pending, Lordship.
Hard, Mr. You're good in?
Honi Tana Tara, Lordship.
You know what number? What's it? Hard, Mr. H.T. Tara. Hard, Mr. H.T. Tara, the learned counsel for the petition, and also hard M.S. Elhage, the learned additional PP, appearing on support. State respondent. And it's a joint application filed. Section 482 CRPC. Paying for copying of the FIR dated 4/6/2023, which is registered as ITA VS case number 124/2023 under section 279/427 IPC, and the charge sheet number you have given?
They have not angered charge sheet. Whether it is charge sheeted or not, I have no idea.
Charge sheet number you have given.
GR number is dear Lordship. GR number 397, Lordship.
GR number charge sheet has given. Charge sheet has already been
Yes,
submitted.
according to that, Lordship, charge sheet has
Number. Corresponding to GR case number 379/2023. Under section 279/427 IPC. Right, it's not submitted by the learned counsel for the petition that misunderstanding. So one dog came from his car. That who is the petitioner? I mean, number one is the informant or?
number one is for
Two is informant, Lordship.
yes, two is informant.
That the petitioner number two is lodged in FIR due to some misunderstanding between the parties. And have you annexed the FIR? FIR, na?
FIR annex, Lordship.
Page 12, Lordship.
The allegation that the petitioner number one has hit had hit the vehicle of the petitioner number one as he was driving the car in a rash and negligent manner under the and he was intoxicated at the time or relevant time of incident. For which the vehicle of the petitioner number two got damaged. But the actual fact is that the relevant time of incident when the petitioner number one was driving the car and was driving the car driving his car, suddenly one dog came in front of his car, and in order to avoid and in order to save the dog, he took a sharp turn and unfortunately had a minor collision with the car driven by the petitioner number two. There was a minor damages in both the cars, but subsequently, after the institution of the case, both the petitioner number one and two had several discussions. And accordingly, in intervention of the family members and other persons, they came to a compromise, their settlement, and on the basis of the amicable settlement, both the parties have also entered into an agreement Which is the agreement? In page 17,
Yes.
agreement on 5
September, Lordship,
5 September. 5th of September.
Lordship.
Yes.
5th of
It is-
September 2022. And at present, both the parties are living peacefully without any differences. The both the parties are also agreed to repair their own respective cars. According to petitioner number 2 is not willing and interested to proceed with the case further. And hence, there is no probability of, there's a big chances of conviction, even if the proceeding is allowed to be continued. Rather, it will be a abuse of the process of the court. The learned counsel further submitted that, as the matter has already been settled between the parties and same is private in nature. It is a private in nature, the exercise of power under section 482 CRPC can be invoked to cause the criminal proceeding as well as the FIR laws against the petitioner number 1. Next, in this context, MS Al-Hadi, the learned counsel for the petitioner, learned that is has submitted that as the matter has already been settled amicably between the parties, and both the parties also agreed to repair their respective cars, etc. The prosecution has no objection if the petition is allowed under section, if the petition is allowed and the proceeding is paused. Considering this submission made by the learned counsel for both the sides, and also considering the views of the Honorable Ethics Court, I am of the opinion that it is seen that both the parties have arrived at this settlement, and case is purely private in nature, and also considering the view of the Honorable Ethics Court, so also can discuss.
Much of that. My lordship. This is regarding civil revision.
Not yet admitted, or
At
matter is not yet admitted.
not yet admitted, but this matter may be disposed of. This is the only very this limited question is there. Matter may be at admission stage, matter may be disposed of. There is nothing to be
So you are agreeing
on
for?
law point is
Also,
there.
I'm for the deputy commissioner, but then private respondent is there. This is between the private respondent and the main case is between the private respondent and the petitioner. And the private respondent has not done that yet.
Kindly see page number, this order dated 7/8/2023. I have filed affidavit stating that as per the direction of this honorable court, I have filed, published the name of this private respondent before the newspaper. And they're not this ready to turn up private respondent. That is why the order has been passed, matter has been fixed for admission. And at this admission stage, the matter is fit to be disposed of because there is a limited question issues to be settled here. Because only the issue, only one issue is that the legally the deputy commissioner has no jurisdiction to admit or transfer the case. This case. Only jurisdiction error is there. Even if as per this Civil Court Act, the deputy commissioner has no power to try that. Neither the ADC nor the deputy commissioner. This Civil Court Act, Civil Court has the power. At that point of time, this this admittedly,
When the civil court was in existence, in that time it was done?
yes,
order was-
kindly see.
Prior to the,
Civil Code Act, Civil Code was, it was 12 April 2021. It has come into
12
force
April
2021.
2021.
Yes, this case was page number, kindly see, page number. Order date 16/4. Page number 48 NFA 5, kindly see. Case has been admitted on 16 April 2021. Whereas civil court has come into force on 12 April 2021. And on 16 April 2021, case has been admitted by the court.
It is a very marginal one. to take this.
That is this. The court cannot admit. The deputy commissioner has no power to admit. That is why if the parties agree, they can file before the, against the Kavang decision. If they are admit, they can go to the appropriate forum. Civil court is there. DC has no power.
The civil court act came into force also here, and as you have submitted here, from here, it is
Right,
that
it
effect
is.
of April 2021. So order was passed on 16 April
Yes.
2021.
16
That
April.
is what is the
16 April.
existence of so and so. Okay.
Lots of with observation, this can be set aside.
Matter may be
Pardon?
disposed
Yeah, matter can be disposed of also.
with the
Your-
observ-
your
with the
is
observ-
With the, yes,
The only submission is that after coming to existence of this act also.
Yes,
He passed the order or.
he has passed the order. Whereas, the private respondent has another remedy before the appropriate forum. If they agree, private respondent agree, they can go to the appropriate forum. But the decision of the deputy commissioner may be set aside. Because as per law, he has no jurisdiction. The deputy commissioner has no jurisdiction. This is the issue. Only limited issues there. On record.
So what is where is the order? We have annexed. Order is annexed at
Yes, annex.
16/4 order, no?
16/4 order, this is admitted the case. And after admitting this case, after when civil court has come into court, then matter has been admitted illegally without any
No,
jurisdiction.
no,
Then
16/4/21, it was admitted.
16/4/2021, deputy commissioner has admitted the appeal,
Then it
appeal,
was-
Kavang appeal. This is the customary court. Against the customary court, he has filed appeal before the private respondent has filed appeal before the deputy commissioner. And deputy commissioner has admitted that on 16 April.
Thereafter, he passed the order on 17/12.
Yes, then 17/12 for transfer of the case to the additional deputy commissioner, stating that the place of occurrence is within the additional deputy commissioner. Whereas neither the deputy commissioner nor the
Where you have
additional
annexed
deputy.
the 16/4 order and 17/12.
Yes, Both the-
16/4 order is a
yes,
page.
16/4 order is there, 17/4 order is here.
No, 16/4 order first,
16/4 order is page number 48, Annex 5,
page number 43.
48, 40,
Okay.
Annex 5. Appeal is admitted and directed to forward filing copy of this. This is second.
And thereafter he transferred
Yes,
the matter
and-
on 17/12.
Yes,
17/12, we have annexed it.
directed to transfer the record to ADC Meher immediately. This
17/12
is
order
also
is,
illegal.
no,
Yes.
17/12 order is at page 58.
58 Annex 8. Both the order may be settled.
And the Keba decision was it?
We did liberty to,
No,
liberty.
no,
to-
Keba decision, we have annexed the Keba decision also.
Uh,
Keba
Keba
decision.
decision, yes, I have admit, annex. Keba decision is, I'm the degree holder here, and they're the appellant.
You
I'm
are the
not the-
degree holder.
yeah, Yes,
Against the decree they have appealed.
my against this
Against
degree,
you.
they have.
Yes.
This, Keba decision is, page number 31. Ex parte decision. That is in local language Adi,
Oh,
but it is translated into English.
translated English,
Yes,
translated.
translated version is kindly see page number 39, 39, 40, 41, 42. 39 to
Keba
13.
decision was of 12/2/2021.
Keba decision is of,
12
yes, 12 to 2021. This is against this Keba decision.
The
Private
different
hospital has
party
filed appeal before the appellate court.
Yes, you have filed the affidavit in opposition also.
Yes, Lordship. Lordship, here, if we come to page 43, Lordship, of the petition,
40?
43 of petition copy,
Ah,
Lordship. This application has been filed on to the Deputy Commissioner, Lordship, is 26 March 2021. So till then, this has not come into force, this Arunachal Pradesh, Lordship, Gazette notification. It has come into force in April 12, 2021 only. Lordship, if Lordship come to my affidavit in opposition, page 19. Page 19, Lordship. Lordship, this is the act. Lordship,
yes.
19, second para, Lordship. Second para, provided that any appeal or civil suit pending in the courts of Deputy Commissioner shall be disposed of by the concerned Deputy Commissioner under the provisions of the Assam Frontier Administration of Regulation 1945 expeditiously as possible, but not later than 1 year from the date of coming into force of this act. So 1 year time was given. So keeping in this thing in mind, the Deputy Commissioner must have admit the matter, and according to the Lordship, this act itself, if your Lordship come to page 9, Lordship. Maybe
Page
wrong.
9 of
Page
your-
9 of my my affidavit, Lordship. Wrongly or rightly, Lordship, they have eight parties, section 16, they have. They have transferred the, given the power to the ADC, Lordship. Section 16, Lordship. Appointment of ADC, Lordship. The administrator may appoint an ADC or for the trial of particular cases when he thinks fit, and may direct that such ADC shall for the purpose exercise all or any of the powers of the Deputy Commissioner. Most probably because because this is a tapped case, Lordship. This particular case is a tapped case, Lordship. Maybe under this impression he issued the order.
So now apparently from the act itself, it seems that the Deputy Commissioner has the authority or power for 1 year.
Yes,
1 year.
1 year.
Was 1 year, and the application was filed in the March 2021.
Yes, March 2021.
It is 2023 now.
No,
Now it is
2023 means.
Yes.
Already
Mm.
time is done. Even if this honorable court
Time
directs
is- Now, that will be a different aspect, because
Yes.
we were on the ground that it was illegally been admitted, and it was transferred is also illegal. But
Without
it was
any power.
Submitted without any authority or power.
Yes.
The question is that, they raised the question that within 1 year from the enforcement of this act also, it can be done. So matter is, seems that it was in 2021, March 2020.
March 2020.
There is nothing wrong.
Only
In the
only-
order.
Only this case is that Lordship, as per the complaint on record, it is as it appears case appeal was filed on 26 March 2020. But matter, this is the Deputy Commissioner office, and matter was not heard. And matter court sit on 16 April, whereas on 16 April 2021. And before 16 April 2021, on 12 April, the Civil Court Act came into force. This is the issue.
All right, this is the issue. But
Yes.
the question is, as per the submission of the Government Council, the question is that the deputy, as per the Act of Council, the Deputy Commissioner has the authority to proceed with the case till 1 year
Yes.
of the enforcement of the
This
act.
is, as per the Civil Code Act, this section 15 says, as per the, this is the case where if the appeal is pending, it is to be disposed of. Then the pending matter, the Deputy Commissioner has power to execute it within a period of 1 year, not to take new case, but the pending case, if it is not disposed within a year, the Deputy Commissioner is duty bound to transfer the case before the civil court. This is
Yes, what he was going to say
This is the
here in
case.
this case.
this is the.
Here I
Whereas in
pointed
this
out
case,
that
it was
the
yet to be
So the
disposed.
petition was, the appeal was admitted obviously
Yes.
after the release of the act.
Yes. This is the
It was
After the
not a pending matter, but a new case
new case,
wherein he admitted the appeal on 16/4.
16.
That is the
This is the issue. I'm like,
okay. Heard Mr. Peter Park, the learned counsel for the petition, and also heard. Yes, your government MSG at the MS? G at the the learned, the government counsel, okay, government advocate from the state of Arunachal Pradesh.
For 1 and 2.
From appearing on behalf of 1 and 2. However, from the order dated 7/8/2023, it is seen that the case has already been proceeded ex parte against the petitioner respondent number 3, who did not appear before the court even after the paper publication. No, proceeded ex parte. That must be proceeded ex parte. The learned counsel for the petitioner submitted that the present petition is based only 2 issues as to whether the Deputy Commissioner has the authority to admit the appeal on 16/4/2021 after the after the enforcement of the Arunachal Pradesh
civil court.
Civil Act 2021, which came into force from 5th of April 2021. He further raised the issue that the Deputy Commissioner, without having any authority, not only admitted the appeal on 16/4/2021, but also by order dated 17/12/2021, transfer the appeal before the additional Deputy Commissioner for disposal, which is also without any authority of law. Which is also done without any authority of law, and hence the order of 16/4/2023, whereby the appeal against the Gaba decision was admitted, as well as the transfer of the appeal before the additional Deputy Commissioner for trial is arbitrary and illegal and passed without any authority. So, after raising those 2 issues, it is submitted that from the act itself, it is very clear that the deputy commissioner, after the enforcement of the Arunachal Pradesh Civil Code Act, bears no authority to proceed with any appeal, new appeal or case. Cannot proceed with the appeal, which is filed against the KEBA decision. Next one. In this context, MSGAT, the learned government advocate, has submitted that the application for appeal was filed on 26/3/2021. Yes, before the learned deputy commissioner against the order of the KEBA decision, against the order of the KEBA. And page number 43 also. It is the ex parte KEBA decision dated 12/2/2021. 12/2/2021, and same has been admitted on 16/4/2021. It is admitted fact that the act came into force on 5th of April 2021, but as per it was a section.
Section 15 of regulation.
As per, but as per.
This civil code.
15.
15, one side.
As per section 15(3), as
15(3).
per proviso of section
Proviso.
15(3) of the edition of Civil Code Act, it is provided that any appeal or suit which is pending before the deputy commissioner. It is provided the deputy commissioner has the authority to dispose of any appeal or civil suits pending before him. Prior to the enforcement of this act, expeditiously as possible, within 1 year from the date of enforcement of this act. Further, she submitted that as per the act also, as per the criminal proceeding, this is the chapter 3, no? The other part, chapter 3 of criminal.
Chapter 3.
Assam Frontier. Further, it is submitted that as per Assam Frontier Administration, next Assam Frontier in bracket of Administration of Justice, Regulation 1945.
Yes.
The deputy commissioner has the authority or power to entrust an additional deputy commissioner to conduct the case, to proceed with the case as per section 16 of the said act. For full stop. Accordingly, she submitted that apparently no illegality has been committed by the learned deputy commissioner in admitting the appeal as well as transferring the same before the court of learned additional deputy commissioner for disposal. In this context, Mr. Tapak, the learned counsel for the petitioner, has submitted that it is a fact that the commissioner has the authority to dispose of the matter within 1 year if in case of any suit or in case of any civil suit or appeal is pending before this deputy commissioner. But here in the instant case, it is seen that though the application for appeal was filed on 26/3/2021, but the appeal was admitted after the
16 April.
Admitted on 16/4/2021, that is after the enforcement of the Civil Act, Arunachal Pradesh Civil Act, and thus it is the deputy commissioner has the no authority to admit the appeal or to transfer the matter or to transfer the case to the additional deputy commissioner for disposal. He admitted that if the matter would have been pending before the deputy commissioner for disposal, in that case, as per act, he would have the authority to dispose of the matter. But it is a new appeal which was filed, which was admitted by him only after the enforcement of the act. And accordingly, he submitted that the deputy commissioner act illegally and arbitrarily while admitting the appeal, as well as by transferring the same to the additional deputy commissioner. Next one. After hearing the submission made by the learned counsel for process, I have also produced the case record and especially the act, especially the Arunachal Pradesh Civil Courts Act. The present, the appeal was filed against the ex parte Keba decision.
12 February 2020.
Keba decision dated 12/2/2021, wherein the present petitioner for the decree, ex parte decree, and against the said ex parte decree, the respondent number 2 preferred the appeal before the learned deputy commissioner. But it cannot be denied that the appeal was admitted and the deputy commissioner on 26/3/2021, but at the same time, it is also the admitted fact that the appeal was admitted by the deputy commissioner on 16/4/2021 after the enforcement of the Civil Court Act. Accordingly, I find that the order was by the commissioner while admitting the appeal by order dated 16/4/2023, as well as the order of transferring the matter dated 17/12/2021 is illegal and liable to be set aside in this is criminal division. Sorry, civil division. Accordingly, in this properly civil division petition is disposed of accordingly. However, the respondent number 2 is at liberty to appear in the proper civil forum if he is aggrieved by the order of KEBAS or ex parte decree of the KEBAS decision. Then along with yes.
Yes, I will. This the regular second appeal, my lord.
Now, regular second appeal, you have one is the substantial question. Oh,
Yes.
this is substantial question of law.
Is there, my lord?
Huh?
Is there, my lord? Otherwise, also, my lord, this I am impugning the appellate decree, my lord. Now, as there is no concurrent finding, my lord, that itself is a good ground for hearing the second
There
appeal.
were no concurrent findings.
No, no concurrent finding.
But we'll hear the matter on 100 CPC, I think.
Today it is listed for past time, my lord, as I am praying for staying of the impugn appellate order, my lord. What happened in this case, my lord?
No, I'm not admitting the appeal. I cannot pass this the order. Now, this is the procedure. The question is that I have seen somewhere it is has been given that stay has been passed and appeal has been admitted without formulating the substantial question of law.
No.
But I don't think it is the proper procedure. So I want to hear you on the substantial question of law.
Well,
Fix it.
my lord, to hear that, my lord, my humble submission, notice to the other person, other side will be required, my lord. It
Now,
is
that
today,
is
my lord.
also one of the aspect. The
My lord.
question is that notice Actually, the respondent, we can admit the appeal on the basis of the substantial question of law if it is at all maintainable. In that case only, the appeal will be admitted, and after the admission of the appeal, matter of stay and issue of notice will come.
No, madam.
So that is the procedure, so I want to hear.
No, my humble understanding, my lord. If that be my humble that procedure, my lord, the two prejudiced litigant, my lord. Here is a case, my lord.
So I'm here.
My lord.
List the matter accordingly. I have heard Mr. Alpano, the learned counsel for the appellant. List.
No, my lord, before that, my lord, as a for that issue, my lord, I
No,
will
I'm
be
not going to hear now. List the matter accordingly. 50 minutes over the case. Huh? 22. 22 can be good. On 22nd of maybe for hearing the substantial.
My lord, my humble understanding, my lord, for that notice to the respondent will be required, my lord. In present of both the party, my lord.
Then will get the opportunity after the admission of appeal. They will come and will get the will be the opportunity to hear the matter.
Amen.
And if the on the basis of that formulation of the substantial question of law, appeal is admitted.
That's why, my lord.
Or appeal can be disposed of, it may not be admitted also. That is it.
That's why, my lord. That's why, my
No,
lord.
that's why I'm not going to hear you.
But-
So I'm hear you, I'm going to hear on
Oh,
22nd
Oh,
of.
only 5 minutes, my lord. Only 5 minutes, my lord. That's why, my lord. Issued, if suppose there were suppose two concurrent finding by the lower court, then in such situation,
Now, will similarly only prima facie will consider whether there is any substantial question of law to admit the appeal or to hear the appeal finding.
that's why, my
Or
lord.
to hear the appeal finding.
I do
Isn't
appreciate
it?
that, my lord.
So
I do.
if we see that there are some law involved in this case as well as. supposed
That's
law.
why, well,
In
I do.
that case, we'll admit the appeal, will issue it.
I do, my, concede that, my lord. I do consider. My humble, only humble submission, my lord. That law of second appeal for the in substantial question of law is applicable to the situation where there is a concurrent finding by the learned court will matter. Here is a case, in my case, the past court, my lord, original court degree in my favor, my lord. Thereafter, appellate court, my lord, reversed that order, my lord. Now, when the situation, my lord, there is no concurrent finding, my lord. That itself, my lord. I am relying on one episode. That itself is the ground, my lord.
We will hear on 22nd.
22nd, my lord, my lord. Yes, my lord, this is on the basis of this impugn order, my lord. I have made a categorical statement, my lord. Now they are
I'll hear on 22nd.
They are no, my lord. If my lord, if there's an order, my lord, the appellate court, my lord, to
No,
the,
that's all.
pardon, my lord, of appellate court, my lord, directing the civil learned court below, my lord, if to pass an order on the basis of this order, my lord. If this order is not stayed, my lord, ultimately my grievances, my lord.
That's why I'm giving on 22nd only, 22nd of November.
22nd, my lord, with,
Or okay, then we make it on 20. I'll be here on 20 of this month. Because next week this may not be possible, lots of cases have been faced. May not be possible. You are trying to find it, full man.
well, my humble submission,
I want.
on Monday, my lord, if my,
Monday, we are not sure about it, whether the Monday what will happen.
only my,
No. We are not on that.
my humble
Monday
sub,
picture is a bit different ways.
only issuance
At
of,
present.
issuance,
Listen to me.
My-
Picture is a bit
I-
different.
I do.
Monday may not be here. One judge may not be here. One judge may be here. Two judges may be here. I don't know what will be the situation on Monday.
Monday.
Because Monday in the principal said there's a holiday. Monday from since Tuesday I'm having my bench at principal said, but there is a question of extending of my bench here at Bhubaneswar with Justice Chaudhary.
Then my
So that
locality,
is the question. So Monday cannot be given, I think.
oh, but
Or
then
if I give you Monday, then it may not be hard as because no judge will be here.
my locality, Tuesday, my lord. Yes, I have made a categorical statement.
Tuesday, I
They are
think-
trying to dispossessing me, my lord.
15? Okay, then we'll give you now 15. Not before that.
Obviously.
I mean, Monday position is quite contradictory position is there.
Yeah.
Well, maybe court may be there, one court may not be there.
Otherwise, I have,
Okay, you submit all.
obviously.
No, only 7 for dance. 7 to simple admission, then I'll pass the application, otherwise take a break. Is there any other submission? It is the admission matter,
Admission listed for first time.
listed for first time.
Ah.
So can a notice be issued?
Notice may be issued and this impugn order may be kindly suspended.
If an order is there.
Impugn order is there. Basically, my lord, as your lordship is well aware, lordship. Honorable Apex Court has repeatedly said that while framing the issues under order 14, while exercising the provision under order 14 and under order 7 rule 11, that is the preliminary hearing, the written statement cannot be taken into consideration for the dismissal of the claim at threshold. So many judgments by the Honorable Apex Court. In this case, what learned civil judge senior division SEPA has done. Our case, we have filed title suit for declaration of right, title and possession over a land that is nearly 1 crore 30 lakhs around square meter. That is our forefathers' land. So other side, they have simply come and filed a written statement saying that in the year 2007, we had entered an agreement with the plaintiffs, wherein plaintiffs agreed that this land will be the common land of all the.
Was there any issue, preliminary issue regarding the maintainability or whatever? Is there any?
No, no issue it was framed. Simply after filing of written statement, one date given
On the
hearing,
basis of the written statement, it was disputed.
completely on the basis of written statement. Plaint was nowhere whispered even in the impugn order. Therefore, this is a big case, lordship may issue notice and suspended this impugn order.
As per the impugn order, what is there any stage of execution or any?
Nothing such kind of thing is there. But then what happened, my lord, lordship? The land which is under dispute means completely, it is our land only, this appellant's land. Some highway construction is going, it will be going on there. For that, acquisition notification was there. Accordingly, we have participated in the hearing procedure. And in our name, in our respective names, all the appellants, compensation, it is there, already marked, and even it is kept with the authority to be released. Meantime, when it was finalized, when the compensation, it was about to disburse, then this respondent side, they have lodged a complaint, saying that we have a dispute in this property, so this may not be disbursed. So accordingly, we have exhausted all the other remedies. Before Kebang also, we tried to settle the matter. Ultimately, when every remedy it was failed.
Present, the disbursing of the compensation is, what is there? What is the process now? What is the stage now?
That is, rest of the other beneficiaries they have received. But with regards to ours, that is kept with some third party, subject to the outcome of this debt title suit which was dismissed. So now after passing of this impugn order, the other side is saying that we have won the case, now you have to give the compensation amount to us. And that amount is more than 1 crore something. That is our amount.
Where is the order? The
Impugn order is page 113, lordship.
Yes, this is the order.
In order itself, lordship will would come to know that the dismissal is completely and heavily relying on the written statement of the defendants, that is the respondent here in this case. Kindly come to page 130. Third paragraph. The defendants filed a written statement wherein they enclosed deed of agreement dated 8/5/2007. Completely based on this document only, my suit plain it was dismissed. It is stated that the disputed land is a common land of all the members of Sangchaju of Lada Circle. Therefore, the plaintiffs cannot claim right, title, and ownership of the disputed land unless all the bona fide members of the Sangchaju clan of Lada Circle are authorized.
Have you, where you have approached for to stop to hold the compensation, disbursing of the compensation? You have filed a petition before? No, the process of the compensation is in respect of your land or whatever is in hold.
Is in hold.
It is not yet not disbursed.
It has
So
not.
where from you got the relief or the order of so and so? from the deputy commissioner or?
No, Deputy Commissioner, what happened? I have averred in my appeal petition also.
Then we will send this order you want to get it stayed by this.
Stay, my lordship, and it is not going to prejudice the other side also. They can come and contest, because in this manner, if suit is dismissed, rejected, that is not permissible as per repeated decision of the Honorable Apex Court. One judgment I am relying, lordship, that is, let us, lordship may kindly only peruse the head notes. This is of 2021 9 SCC. Sridhara Hanuman Das Totola. Kindly see the head notes of C, lordship. There is C. Civil Procedure Code 1908. Order 7 Rule 11D, rejection of plaint, guiding principles for deciding application under Order 7 Rule 11D. Law summarized. Only the averments in the plaint itself may be considered at this stage. Held to reject a plaint on ground that suit is barred by any law, only averments in the plaint will have to be referred to. Defense made by defendant in suit must not be considered while deciding merits of the application. Held, on a perusal of the authorities, the guiding principle for deciding an application made under Order 7 Rule 11 DCPC can be summarized as follows. 1. To reject a plaint on the ground that the suit is barred by any law, only the averments in the plaint will have to be referred to. 2. The defense made by the defendant in the suit must not be considered while deciding the merits of the application. 3. To determine whether a suit is barred by res judicata, it is necessary that the previous suit is decided. The issues in the subsequent suit were directly and substantially in issue. Res judicata and other, like in our case, it will become under estoppel, lordship. So until and unless the document is proved, 2007, which this defendant has submitted, on the basis of that, how our suit can be dismissed, lordship.
Mr. K. Thamma, the learned counsel for the appellant. And this is an application under section 96. Related with Order 41 of CPC for setting aside and quashing the Indian order/decree dated 15/9/2023, whereby the learned civil judge senior division SEPA has erroneously dismissed number 1 2023 1/2023 by holding that the suit is not maintainable in the account of Estoppel by heavily relying on the written statement as annexed in the and its annexed agreement dated 8/5/2007, but on the basis of written statement. Considering the submission made by the learned counsel for the appellant, the appeal is submitted for the advocate, issue notice to the respondent side. Further, it is submitted with motion to the respondent side to register daily and as the process. Next, further the learned counsel for the appellant submitted that at present over the dispute there is a construction of what land this
highway
construction of highway over the disputed land, and the question of compensation is disputed and wherein the petitioner should get the compensation of his land, but the appellant should get the compensation of the land, but after the order passed by the learned civil judge dated 15/9/2023, there's every possibility of claiming of the compensation over the said land by the respondent, and on the strength of the said order, post of in that event, the petitioner will be subjected to prejudice will be caused to the present appellant. Accordingly, he paid for the stay of the impugned order dated 15/9/2023, passed in, that is suit number 01/2023, by the learned civil judge senior division SEPA. Considering the circumstances and the prayer, considering the prayer and the circumstances of this case, lately or in order dated so and so this date till return of the date. List of proposals.
Highly ordered.
With one submission can be made earlier, the learned counsel for the appellant court has submitted that the claim cannot be rejected only on the basis of the statement made in the written statement. And in this context, he also relied on the decision of Honorable Apex Court reported in 2021, 9 SCC, page 99.